When I tell clients that their will can be challenged, they get quite upset and they say, "Oh, Professor Davies, it's not right. I I have should be given an unfettered right to make a will which no one can challenge. After all, it's my assets, not the government's, not the courts." And I just want to correct that. The the this will is being drafted pursuant to the Wills Act in your state, whether that be New South Wales, Victoria, ACT, Northern Territory, WA, Queensland, Tasmania, or South Australia. Under the Wills Act, this will operates. If we didn't have those 8 Wills Acts, then you wouldn't have the privilege. You don't have an inherent right to make a will to dispose of the assets. And some countries don't. They have an act of part. They have another set of rules. But you've been given a privilege in making a will where you can leave assets to wherever you want to leave them to. But under the Family Provision Claim Act, the Families Provision Application Act, the Testator's Family Maintenance Claim Act, or the Family Provisions Claim Act, certain people can challenge your will. And if they're going to, then there is something we can do which is called inserting a considered person clause into the will. And that's what we're going to do. But let's look at firstly who can challenge your will. It's one up being your parents, one across being your mistress, your gay partner and your wife or husband, and you can have all three. One down is your children of any age. 2 down are your stepchildren, but only if the stepchild's living with you or the parent is dead. So that's the 4 groups that can challenge your will in all jurisdictions across Australia. But a few years ago, we had a very strange situation in New South Wales where a former spouse, they'd been separated for over 11 years, divorced for 10, and yet the wife was able to claim off some of the assets in the will. So now we do not rely on the fact that you've got your divorce, you've got your degree absolute, you've done your property settlement. We're not going to rely on that. So if you've got a former married spouse, they should go in here. So let's do that now. So if no one's going to challenge the will, press no, press next and get on with your life. But if someone could potentially challenge the will, press yes. And in this instance, your ex-husband, his name is Terry James Bunderchuck. You don't know his address because you haven't seen him for 20 years, but you do know he lives in Angola. No, he doesn't. He lives in Austria. You sure? No, he lives in Australia. Well, okay, so last known in Australia. So now we've got Terry James Bunderchuck, and a considered person clause will now be inserted into your will. Oh, Professor Davies, I don't really want to have something mean and nasty about Terry. No, it's the considered person clause is not mean or nasty. It merely just states that you've considered that particular person, you've considered the circumstances, and you've stated that you're going to make no further provisions. It doesn't have long, complicated stories. If you've got a long, complicated story or some evidence, then certainly collect it all up and keep it with the will, and your executors can choose to use it or not choose it as they see fit. So what's the value of a considered person clause? How do the courts interpret it? Why does it make it more difficult and expensive for Terry to challenge your will? Well, 3 reasons. Firstly, it shows a deliberate choice not to leave Terry anything. It's not an oversight. You just didn't miss out one of the children. It's a deliberate statement that you will not be leaving everything to that child or that ex-husband of yours. It also addresses that you've considered your obligations to that person, because you There may be things that you need to give him during your life, or one of your children got a red bike and the other one got a blue bike that was secondhand. There's lots of complicated stories that people come up when they challenge a will, but you've addressed those obligations. You've said so in the considered person clause, and that's enough. It also gives excellent context to the court. So while a considered person clause does not stop Terry from making a claim, nothing does, but it stops him from making it easy. And the considered person clause carries real evidentiary weight. So what's that? You've left $1,000 in your will to Terry as a Pacific gift, knowing I don't like Pacific gifts, but you've still done it nonetheless. Well, that does not work. Oh, yes, it does. Everyone does it. I've seen it on TV. It doesn't work. Leaving $5,000 or some small amount of money in your will to a beneficiary that you don't want to benefit is incorrect and wrong. And it's wrong because the person now has the privilege and right to be a beneficiary. They're now a beneficiary named in the will with all the rights and privileges that any beneficiary, whether it just be $5,000 or millions of dollars. And it does not prevent a claim either. It just really confirms their standing and invites scrutiny. It's a silly thing to do. And I know you've seen it on TV and what have you. It's not right. Now, we've got a child too that been set up in business a number of times, given a lot of money, and we're going to remove that child from the will, and his name's Fully Jacko Smithy. So we put Fully Jacko Smithy in the will, and there'll now be 2 considered person clauses. Doesn't stop them from challenging, but makes it expensive and difficult to do. Now, that's the end of our wills. So we've got all these questions we've answered. Things in red have not been answered to our satisfaction, to the law firm's satisfaction. And remember, our law firm's responsible for this document. We're responsible for the legality of this document. The next question we're moving into relates to powers of attorneys, which we'll come to in a minute. But in fact, you get 3 documents here. You get your own, it's called the singles bundle. You're going to get your will, your 3-generation testamentary trust will. You're going to get an enduring money power of attorney for your particular state. And you're going to get a medical lifestyle power of attorney for control of your body. So there's 3 different documents. We've built the first one. Before we move to the power of attorney and which state you're going to do the power of attorney for, I just want to look at one last thing on burial arrangements. Now, you do not own your body, and therefore you should not mention burial arrangements in your will. Professor Davies, I'm Muslim, and Muslims have a very particular way of... And look, I know all that. I know you're Catholic and you want to be buried, not burnt. I know that. But it's not the right place to put it. If you've got some issues that you want to give, some advice you want to give, speak to the executor, because the executor controls your body generally. But they're not bound by anything you put in your will. So all you're doing is cluttering up your will with things that will end up damaging your will. If you do want, you can prepare a funeral wish list. It's not binding on the executor, and you can get that free on our website. So do not try and put in burial arrangements in a will. It's the wrong place. It doesn't work and just ends up making your will difficult to be dealt with. So finish the will. Well done. We now move to the second document, the enduring power of attorney.